We will call the next case, which is People versus Curtis Hampton. This is a mini oral argument on the application. You have 15 minutes each. Mr. Eggert, you may reserve and try and keep track of it yourself, and you may proceed when you're ready.
Thank you. Good morning, and may it please the court. Jason Eggert from the State Appellate Defender Office on behalf of Mr. Hampton. This court should adopt a rule that an enumerated felony must be distinct from the act of murder by requiring either a separate act or a distinct mens rea. This rule is consistent with the plain language of the felony murder statute, which elevates a murder committed in the perpetration of an enumerated felony from second to first degree murder. It's also consistent with precedent from this court, including People versus Aaron, which held that malice may not be imputed from an underlying felony, and the traditional justification for the felony murder rule, which penalized murders committed during the course of an inherently dangerous felonies more severely than a non-premeditated murder. The rule applied in People versus Magyar and by the Court of Appeals in this case is inconsistent with these principles. First, because the murder and the enumerated felony of child abuse share the same intent and are based on the same act, it cannot be said that the murder was committed in perpetration of another offense. Second, it improperly elevates children to the special victims section of the statute when the legislature limited the individuals included in that section to police and corrections officers. And third, it's inconsistent with the malice requirement imposed by Aaron because a jury cannot meaningfully evaluate whether there is malice when the murder and the enumerated felony are based on the same act and share the same intent. The felony murder statute doesn't penalize murder committed in the perpetration of murder. Instead, it requires the commission of a murder and in the perpetration of a distinct enumerated felony. And with that, I'll accept the court's questions at any time.
Thank you. I'm going to start with Justice Bernstein this time. Justice Bernstein.
Good morning, counsel. Welcome to the Supreme Court.
Thank you.
Justice Bernstein, I think you muted yourself again.
Awesome. Am I back? Cool. Just a quick question. Wow, very dramatic for this one question. But it's a simple question, and I like to sometimes keep things like very simple. Just the question I have is, when we look at the judicial component of this case and we look at kind of your arguments, I understand theoretically what you're putting forth to the court, but what changes? Like what would change in this situation? I mean, ultimately murder is pretty much the highest crime that can be committed. And per your argument, what ultimately changes? What's the significance of if this court were to act? Why is this a case that we should really delve into, or why is this a case that really has a judicial impact when you're dealing with the severity of the crime in question?
So the primary significance of the issue here is the difference between applying the felony murder statute, which requires a mandatory life without parole sentence, and then potentially in the alternative to that under our rule, which would be a second degree murder conviction, which includes the penalty up to life imprisonment. The significance of this is that there's a single act. When the statute clearly imposes a requirement that there will, one, be a murder committed, and that second, that it's in the perpetration of another offense that's listed in the statute. In this circumstance, that cannot be the case because there's a single act based on the same intent, which is the intent to do, in the child abuse context, serious physical harm, and for malice, which is great bodily harm, and those two are the same thing. So the main distinction here is between first and second degree murder.
Great, thank you. I have no further questions.
Thank you. Justice Clement.
No questions, thank you.
Justice Kavanaugh.
I just have a question. You mentioned, here and also in your briefing, that this would improperly elevate the victim or a child victim to a special victim in violation of the act, because the legislature then went through the process of specifying special victims. But what do you do? And I believe the prosecutor, or maybe it's Pam who pointed out, it doesn't elevate the victim because it's not just a category of victim. You also need a category of a particular perpetrator. So not every child would be. How do you respond to that?
Well, I think that the prosecutor's argument ignores the definition of person in the child abuse statute. A person can be someone that either has custody in the typical aspect that you'd see as a parent, but it also can be somebody that has authority over a child regardless of the length of the time that child is cared for. So this could be a relationship with a child that's developed over a matter of seconds. If a child is, can you watch my child for a second type scenario, and something occurs, that type of authority relationship can be developed. So I think that in that aspect, I think that the significance of the relationship is overstated in the prosecutor's argument. In addition, I think the same can be said of the type of relationship between police officers and a citizen, and corrections officers versus an incarcerated person. Each individual that would be accused of killing that person has a duty to them and has separate type of relationship between them, but it's based on identity alone. And when there's just a single act, as there is here, and the intents are identical, the effect is to elevate that circumstance to to 1C as opposed to 1B, where it's more properly focused by the legislature. And in those circumstances, it has to be a murder committed in perpetration of another offense. And when the two are the same, there is no another offense. It just becomes second-degree murder.
Okay. All right. Thank you.
Justice Welch?
No questions.
Justice Zara?
Thank you. All right. Is it fair to say you're trying to argue that some variation of the merger doctrine should apply, and that the act of child abuse merges with the act of killing, such that the child abuse cannot provide the predicate felony for application of the felony murder rule?
That's not specifically what we're asking this court to do. We're asking the court to apply the plain language of the statute as it's read within that specific provision of felony murder, but also the special victims section in the context of the case law as a whole. It's our position that murder committed in perpetration of implies some distinction, whether it be a separate act or a distinct intent. So, for example, if someone committed a murder while committing arson, for example, and they may have lit one match and that set off the course of events, that would be one act, but there is a distinct intent involved nonetheless. It involves the intent to set the fire and to do that, even though a death results. The jury would still be required to find malice in that circumstance too as well. But when you get into that situation with child abuse, it's hard to see the distinction. It's an assaultive act with the same intent that malice would require. So we're asking the court to apply the statute as written. With respect to merger, I think that the prosecutor has cited some, the provision in the Code of Criminal Procedure to say that Michigan has banned that, and there's also some case law which would suggest it as well. I mean, in the plain terms of that too, I think there may be some questions whether it would apply felony to felony, because it simply says misdemeanor to felony in that statute. But nonetheless, we're relying on plain language. It's traditional statutory interpretation.
Thank you.
Justice Viviano?
I have no questions. Thank you, counsel.
Counsel, you have a little bit of time left. You may proceed or reserve. It's up to you.
I think at this time I will reserve time for rebuttal.
Okay, thank you. Mr. Saman, you may proceed.
Good morning, Your Honors. Emil Saman on behalf of the people. I will waive my free fire zone, and you can ask questions whenever you wish. So for statutory construction, Your Honor, we don't add language, but unfortunately that's what Brother Counsel has done. He's requiring or adding language to the statute saying it requires a separate felony, a separate act, and even requires, for the child abuse statute, a continuous, prolonged, and multiple acts to even qualify under child abuse. That's simply not the statute. The statute specifically requires, did a death result from the commission of an enumerated felony, child abuse being one of them. And as child abuse required that the defendant knowingly intentionally caused serious physical harm. I don't think there's any question here that a stab, a severe cut, qualifies as physical harm, and a stab wound to the chest qualifies as serious physical harm. Somebody can be stabbed and not die. That would still be child abuse, may not be felony murder. But in this circumstance, you actually have a death that resulted. Or the counsel wants to add the language to show an ambiguity. There isn't one, nor is there one by trying to say that there's a special category being created by the victim here. Again, it's not as simple as saying all children, all child victims. That is not what child abuse allows for, nor is it by the hypothetical brother counsel gave, saying, you could say that this person said, watch my kid for 5 seconds. That first, that's a very unique factual scenario for a hypothetical, but realistically, it has to do with the special relationship of the offender to the child. That is what the child abuse statute seeks to protect, and that is why it became, only for child abuse first degree, a serious crime under the felony murder rule. Therefore, it's not a special category. There's no separate requirement, nor is there any kind of continuous, prolonged, or multiple act requirement for child abuse. All these words or language have been added by brother counsel, trying to create the ambiguity that simply does not exist. So the question is, then he puts much stock into the intent elements. And I think that's Justice Zara got this kind of right on the head. Does this create, is he trying to bring back the merger doctrine or argue the merger doctrine? Or is it really a possibility that he's trying to argue double jeopardy? I don't think double jeopardy is his argument, because the remedy would be to vacate the child abuse and simply keep the felony murder. I do not believe brother counsel wants that argument. However, for the merger doctrine, besides it being abrogated in Michigan, the merger doctrine was meant to ameliorate the issue of having an accidental or negligent killing elevated to felony murder. There's no question that this was not an accidental or negligent killing. Even the defendant himself testified, simply, I didn't do it. My girlfriend did, and that's why I flew into a rage and stabbed her 14 to 16 times. His whole argument was, I didn't do it. Not that this was an accident because I was aiming for her and got the child instead. This was rejected by the jury. The question really is, logically, was he a parent or guardian? Yes. Did he cause physical harm to the child? Yes. Did that result in death? Yes. And in stabbing somebody, did that have the requisite intent of causing great bodily harm or depraved heart? Yes.
Councilman, let me just see
Absolutely.
who has questions, and then you'll have more time if people don't. Justice Bernstein. Justice Bernstein, you are muted if you are trying to ask questions. All right, we're going to return to Justice Bernstein later. Justice Clement.
Just one question. Why is first-degree child abuse not an assaultive crime that's completely subsumed by second-degree murder, like assault with intent to murder would be?
Because you have extra. Is it completely subsumed by the crime? I would argue that that the child abuse, even if it was completely subsumed by the crime, again, I think that's, are we trying to argue a double jeopardy perspective in that regard? So if it's completely subsumed by the crime, I would argue that there are extra elements in the child abuse case, does not require a death. The intent elements are not exactly the same. They are unique intent elements to child abuse as are to the murder second degree statute. And I think this goes a little bit to what Justice Bernstein asked brother counsel regarding, well, what would be the remedy of this? Would it just be a murder 2 charge? Not necessarily. This could be a first degree murder charge, premeditated and deliberate. So I don't think that it would not totally be subsumed in the murder 2 or even the murder 1 statute. The intent elements do not subsume the intent elements exactly.
Thank you.
I'm going to double back on Justice Bernstein. He was muted by against his will. Justice Bernstein.
Well, actually, I am so bad at technology. That's the one thing I have learned from this pandemic is that ultimately I am the absolute worst when it comes to technology usage. So I appreciate and thank you all for dealing with me. Maybe I should take a course or get a little bit more in tune with technology. But anyways, I'm just going to go back to the question that I am just going to go back to the question I had just kind of posed before, which is what what counsel was kind of starting to kind of get into. But the question I really want to ask is, and I always try to keep things simple, but like, what am I missing here in this situation? Again, I'm looking at it from a simplistic way. We're talking about child abuse. What constitutes child abuse? The child was actually murdered, and I know it sounds like a simplistic question, but what I'm trying to garner is, what is it that I'm missing?
I'm not sure how to answer that one, Your Honor. I don't think you're missing anything. I think it was a child abuse, a death resulted, and that qualifies as felony murder.
Thank you. No further questions.
Thank you.
All right, Justice Kavanaugh.
No questions from me.
Justice Welch.
No questions.
Justice Zara.
No questions. Thank you.
Justice Viviano.
No questions, Mr. Saman. Thank you.
Mr. Saman, I think I understand your argument. I feel a little bit troubled that all parental / guardian killings of children will automatically be elevated to first degree, or can automatically be elevated to first degree. That might just be, that's the way it goes. Is that something I should be concerned about? I mean, no matter how, we can all like imagine hypotheticals that feel very not first degree, right? Not every killing of every child feels like traditional first degree, but what's your response to me to it? That's a problem for the legislature, not me.
Yes and no. First, it is an issue. If there's an issue with that, the legislature should make amendments if they desire to do so. However, that question actually came to me, and I spoke to several different prosecutors, and I got a wide range of answers of how they would have charged this case. And I got different answers from some would have charged it under felony murder under the way it was charged, and others would have charged it under first degree premeditated murder because they believe a single stab wound is indicative of premeditation and deliberation. So I think it looks at a matter of perspective. Just like you choose for any charge or any kind of elemental crime, what are the facts of the particular case and which elements would be easier for me to charge or to prove beyond a reasonable doubt to a jury? And therefore, I think there's going to be prosecutor discretion, a matter of perspective, and simply put, everybody's going to have a different idea of what they believe is easier to prove. One could argue that it's more difficult to prove felony murder because you have to also prove the element of the predicate felony, whereas a first degree premeditated murder is simply those three elements that you have to prove, and that's all. So again, I think it's not an automatic. Could it be? I think it will depend on the facts, like any other charge or any other elements, not simply something that's going to happen as a matter of course.
But that's, I mean, I take your point that, prosecutors get to make individual decisions in individual cases. And of course, that's always right. And maybe what you're saying is if it's a particular killing of a child and it, unlike, it sounds like you think this one, and maybe some of the prosecutors you talked to in this one that could have charged it as first degree even without the felony murder, could have charged premeditation. In another hypothetical where everybody agrees there's no way to charge premeditation, all of those cases would have this possibility of being elevated to first degree if your theory is upheld, correct?
Possibly, yes, based upon the facts and based upon specifically what the legislator did by putting child abuse first degree and only first degree in the felony murder statute. If that were not to be the consideration, then that would never have been added to the felony murder rule, and there would be no child abuse enumerated felony.
Thank you, counsel. Any other questions for Mr. Saman? You have a few minutes left if you have other things you want to tell us.
I think I know to stop when I'm ahead, but I simply ask that the Court of Appeals be affirmed. Magyar was correctly decided, and there is no ambiguity to the statute. There was a child abuse. There was a killing that resulted. Therefore, there was felony murder. And we ask that you affirm the Court of Appeals.
Thank you, counsel. Mr. Eggert, you have some rebuttal time.
Thank you. With respect to a point that was just brought up about first degree and only first degree child abuse being included in the felony murder statute, I think there's a reason for that that's clear when you read the child abuse statute, is that the second degree statute, outside of omissions that cause harm, has no requirement of actual harm resulting. So they're not really compatible with each other. Second, regarding the question that Justice Clement brought up about the child abuse being subsumed in the murder, I think that's precisely the case here, and I disagree with the prosecution's argument that there's a distinction in the intents between murder and the child abuse provision here. As I've cited to some of the case law in the brief, it relates to a intent to do serious injury of an aggravated nature when you're getting into great bodily harm, which satisfies malice. The intent to do serious physical harm is defined in the statute. I think clearly mirrors that. As far as the actual merits of the Magyar opinion, I think that there's little to be gained from their analysis as to the actual meaning of the statutory language. What they did in that case was to take the square peg of Jones, which was the Court of Appeals case they relied on, that involved the breaking with intent to deliver or intent to assault, and then applied that to the round hole of the Magyar scenario, which is the same presented here, which is a single act underlying both the murder and the predicate felony with identical intent. And that it's our position that that's not compatible with the statute as written, specifically with the meaning of in perpetration of. It's a murder committed in perpetration of another felony, and that's the factual circumstance presented here does automatically, no matter what, there's going to be no ambiguity. If there is a first degree child abuse that results in death every single time, that will be a first degree felony murder. And under the facts here, there's no distinctive actions and clearly no distinctive intent. I think another aspect of this that was brought up is this isn't a double jeopardy argument. This is an argument about the meaning of the statutory language and the meaning of that language when the statute is read as a whole. And it's our position that this type of single act, same intent scenario, it doesn't apply to the language as the statute is written, or how the felony murder or felony aggravator statutes are meant to be read. There's always some distinct criminal conduct, and I think the rule I've suggested here, which requires that separate act or distinct mens rea, would solve a lot of the problem here and would harmonize the language with this type of scenario.
Let me interrupt you, Mr. Eggert, in case anybody has questions at this point. Is there anybody with a question for Mr. Eggert? Seeing none, you have a little bit of time if you want to say anything else.
Sure. I'll just wrap up by saying that we're asking this court to vacate Mr. Hampton's convictions based on a reading of the statute, which requires some distinctive act or mens rea for the enumerated felony. I think that this rule is consistent with what the statute requires and what the legislative intent is when the statute's read as a whole. And so we'd ask this court to vacate his conviction for felony murder.
Thank you, counsel. The case will be submitted.